Yeah, whatever that one is.
Oyez, oyez, oyez. Anyone having business before the King's Justice of the Superior Court of Justice, attend now and you shall be heard. Long live the King. The Honorable Justice Hennessy presiding. Please be seated.
Good morning, all. We may have some feedback there. Not you?
Real tight up here.
Should we try this? Let me say good morning again. Test. Let me just get my notes.
Thank you, Your Honor. The Hurons were going to start with their reply. I believe Mr. Worm is going to say a few words to begin with, but I don't see him there.
Mr. Worm, we're calling on you if you are available. Is anyone in touch with him? And I should have your.
Be online.
They're having.
We've sent up a reply compendium that perhaps we could take the time to
Very nice, thank
look
you.
at that.
And it would be Exhibit G.
I think that's correct.
Yes, Your Honor.
Thank you. Exhibit G, Huron reply compendium.
They're having
some technical difficulties.
well, maybe I'll just, should I start with something and then we may have to interrupt, or shall we just wait?
Why don't you, well, I can't tell whether what we're talking about in troubles. Your call.
I think the issue is that they logged in as an attendee, not as counsel.
So they're just re-logging in?
Okay, we can wait then.
Make it bigger. Sorry, I've had it at the smallest one the whole time.
I do have two distinct submissions. The first one's quite brief. I could make that now while we're waiting, and then then I'll sit down if Mr. Worm is here.
All right.
You just let them know that's what we're doing. So I'm only going to address two things. First is just to make some brief submissions about Ontario's submissions on the role of the Anishinaabe Treaty Principles. And The second will go to the standard of review, and then just a few miscellaneous issues. And I think that throughout this litigation and the companion case of Restool, we have all seen Ontario strenuously resist the idea that there are any particular principles which must be followed when the Crown makes a decision to increase the annuity. First, they took the position that it was an entirely ex gratia exercise, and then they said there was only a procedural obligation. And it appears that old habits die hard. Because as we understand Ontario's argument, they are still taking the position that the Anishinaabe Treaty Principles are just guidelines, really, and that the obligation to be liberal and just requires nothing more than the Crown to take into account polycentric considerations. We say those submissions are based on a close parsing of select passages of the Supreme Court Canada decision and drawing insupportable distinctions. We say there's just no doubt that the Anishinaabe shared the most important gift they had, their land, with the Crown on the basis of a promise the Crown would act as an honorable treaty partner.
Just going to ask you to slow down a bit. Thank you.
They shared their land, they entered into the treaty, they renewed their treaty relationship on the basis that the Crown would act as an honorable treaty partner, and that includes making decisions under the augmentation clause in a manner consistent with the principles that govern the treaty relationship and acting generously and with love and care. And if the Crown does not make its decisions in a manner consistent with the principles that the parties agreed would govern their relationship, it is not acting honorably. Now, there's no doubt the Supreme Court of Canada confirmed this court's finding that the common intention of the parties was that their relationship would continue to be governed by the Anishinaabe Treaty Principles, that the Anishinaabe expected the Crown to exercise its discretion to increase the annuity generously. I'll refer you there to paragraph 173, and that the augmentation
173 is
173 of the Supreme Court of Canada's decision, and that the augmentation clause is, quote, consistent with the Anishinaabes' perspective reflected in the principles of respect, reciprocity, responsibility, and renewal, paragraph 179. And we say, in the face of these findings, with respect, Ontario's submissions on these points amount almost to a suggestion that the Anishinaabe were duped. They expected the Crown to be generous, but liberality just means taking into account everyone's needs. They expected the Crown to adhere to the treaty principles, but the Crown did not bind itself to do so. And we say, fortunately, the Supreme Court of Canada has confirmed this is not the case. To suggest that an honorable treaty partner does not have to act consistent with the treaty principles hollows out the content of the Crown's obligation and turns it into the proverbial empty shell of a treaty promise. We say the Crown's reading of Restool flies in the face of the extensive factual findings and legal holdings made by this court and endorsed by all subsequent courts on appeal about the nature of the treaty relationship itself, the parties' shared goals, expectations, and understandings, and how those inform the content of the treaty's promise to augment the annuity. It ignores the fundamental finding of Restool that the shared goals, expectations, and understandings of the parties include principles of kinship and mutual interdependence, as well as the Anishinaabe Treaty Principles. Ontario talked about its willingness to learn. Well, we say one thing's clear from Ontario's submissions about the role of the treaty principles. It has a lot to learn. Every court has confirmed that these principles form the foundation of the treaty relationship and governed it for 100 years prior to 1850. And it was the parties' shared expectation and understanding that those principles would continue to govern the relationship moving forward. So we say there's no doubt that a treaty partner who acts inconsistently with the treaty principles is not acting honorably. Do we have? They're not ready yet? So those were just some brief submissions on that issue in response to Ontario's submissions.
Thank you.
So just to be clear, they said the discretion has to be exercised liberally, but the amount doesn't have to be liberal. We say it does. It has to be generous. The decision made has to have a result that's consistent with the Anishinaabe Treaty principles. So my next point is to address the issues on Anishinaabe of administrative, my Ontario submissions with respect to administrative law and the standard of review. And those will comprise most of the rest of my submissions. So I just, are we still waiting for Mr. Worm?
Yes,
Is he's not able to get on?
they're still having trouble.
All right, I'll carry on and then,
Okay, so on this point,
yes,
I will ask you to slow down.
I will.
Thank you.
So Ontario's council gave us all a lesson on administrative law, or he purported to do so, and he did so in what appeared to be a very clear and authoritative way. Here we go. Since I haven't started, I'll let Mr. Worm make his submissions and then we'll pick it up from there because all the rest of what I have to say is of a piece.
Thank you. Good morning, Mr. Worm.
Finally, at long last, we've resolved these issues. I apologize for that, Your Honor.
No problem.
I would begin by just saying Anin, bonjour, bonjour, and good morning to court, to my colleagues there. Let me also say thank you to the court for the indulgence extended to me which permitted these submissions by way of Zoom and to do them virtually. And I thank my learned friend, Ms. Boise-Parker, as well for her indulgence and going ahead and starting in our brief absence. So let me just go ahead then, and I want to speak further about the Anishinaabe and their laws and protocols based on what I've heard over the course of this constitutional review, and provide some further submissions about the trans-systemic Robinson treaties and the Anishinaabe perspective laws and protocols. So my remarks today are organized generally into the following topics. Firstly, that the Crown's exercise of discretion ignores the Anishinaabe perspective at their own peril. Secondly, that the honorableness, liberalness, and justness of the compensation offered must be informed by the long-standing Anishinaabe systems of law and governance. Thirdly, that the principles of respect, responsibility, reciprocity, and renewal are the basis for those long-standing systems of law and governance and are relational. And finally, that reconciliation demands a different approach by the Crown and the common law to learning about and the knowledge of Aboriginal systems of law and governance. So turning firstly, we acknowledge that with regards to the superior plaintiffs, the Supreme Court stated at paragraph 11 that if a negotiated settlement was not arrived at within 6 months of their decision, that the Crown will be required, quote, to exercise its discretion and determine an amount to compensate the superior plaintiffs for past breaches, end quote. It seems pretty clear about the exercise of discretion and where it is to occur in the process. We also note that the polycentric considerations identified by the Supreme Court were, at paragraph 309, explicitly stated to be, and I quote, by no means an exhaustive list. End quote. Therefore, while 5 factors were identified by the Supreme Court, the Crown is not limited to them. And while the Crown could ignore the Anishinaabe perspective in the exercise of that discretion if they want to, they do so at their own peril. It is to their own peril, as the Supreme Court was clear, that their offer needed to be honorable, it needed to be liberal and just. And while the Anishinaabe perspective and the attendant principles were not explicitly mentioned when the Supreme Court of Canada identified the 5 factors, reading the decision as a whole, it is clear that the Anishinaabe perspective must be considered. Admittedly, the Crown could fluke out and settle on a compensation amount that is honorable, liberal, and just. But given their track record, particularly the strong language used by the Supreme Court about how the Crown has treated the treaty relationship, we don't hold out a lot of hope that such a fortuitous result could happen. Turning secondly to the honorableness, liberalness, and justness of the compensation, that it must be informed by long-standing Anishinaabe systems of law and governance. It is the court's role then to determine if the amount of compensation offered is honorable, liberal, and just. And it is here where I return us to the fact that the Robinson Treaties are trans-systemic legal agreements. The Robinson Treaties are at the most land cession trans-systemic legal agreements. There are no clauses ceding Anishinaabe laws and legal systems. As the Supreme Court of Canada has stated in the well-known passage from Vanderpeet about how the purpose of Section 35 is to reconcile the pre-existing sovereignty of Indigenous peoples with the assertion of Crown sovereignty, and that, Your Honor, is found in paragraph 131. This reconciling does not extinguish the systems of law and governance of Indigenous peoples. Such an extinguishment requires, per the Supreme Court, a clear and plain intention on the part of the Crown to do so. We find that proposition supported at Sparrow at 1099. And moreover, it's oxymoronic to claim that the Anishinaabe had jurisdiction to enter into the Robinson Treaties, while implying that said jurisdiction and authority was extinguished through the treaties. There's no historical record anywhere that would support such a proposition. The Supreme Court explicitly acknowledged the long-standing system of Anishinaabe law and governance informed their perspective back in 1850, and it continues to inform their perspective today. That's Restool at paragraph 17. And as Robinson's account of the negotiations of the treaty show, Robinson adopted Anishinaabe protocols and practices wholeheartedly, which would have reasonably given Shingwakans and the other Anishinaabe assembled the impression that the treaties were trans-systemic. It is our submission that it is sharp dealing for the Crown to now turn around and attempt to minimize the Anishinaabe understandings that Robinson clearly understood and adopted. Unless the Crown wishes to argue that Robinson made misrepresentations to the Anishinaabe, which would of course bring the validity of the entire treaty into question. As a result, the trans-systemic nature of treaties is integral to the relationship between the Anishinaabe and the Crown and are more than color of context. The trans-systemic nature is the treaties, meaning that any compensation offered must be honorable according to the Anishinaabe principles that lead the determination of the form, level, and aim of sharing that the parties understood in 1850. The Supreme Court, in paragraph 180 of Restool, It's clear that the determination is led thusly, whether it is in negotiations or before the court. My friend from Ontario made a series of, as Your Honor framed it, quote, fine distinctions, end quote. One being from paragraph 180 of Restuel, where the Supreme Court agreed with the Court of Appeal's conclusion that the exercise of determining the form, level, and aim of sharing should take as being, quote, led by, and not, quote, governed by, end quote, the shared goals, expectations, and understandings of the treaty parties, including the Anishinaabe principles of respect, responsibility, reciprocity, and renewal. Again, the Crown can exercise their discretion however they want, as they always have when it comes to dealing with First Nations, but that does not relieve them of the obligations identified by the Supreme Court under the Robinson Treaties. And that is why we've all gathered here in Thunder Bay, or did gather in Thunder Bay these past weeks. The plaintiffs and the contingent interest First Nations do not believe the amount determined through the Crown's exercise of discretion is honorable. The RHT Anishinaabe are here in part to ensure that the Anishinaabe perspective and system of law and governance is represented, and represented in a form that is not distorted into the neat boxes of the common law. Thirdly, we agree with Ontario that the Anishinaabe principles of respect, responsibility, reciprocity, and renewal should not be applied in the abstract and individually, though we disagree on what that means. For Ontario, it seems that, understandably, they are seeking to protect their clients' interests, and that assessing their offer principle by principle would be detrimental to their client's position. This position, though, in our submission, is contradictory to their approach to the factors identified by the Supreme Court, in which Ontario seeks to fill each factor bucket, if I can put it that way, with various considerations that are assigned and then only considered within their individual bucket. This bucket by bucket approach to the factors is incongruent with the holistic approach that Ontario submitted that this court should adopt when considering whether their offer was honorable. The Anishinaabe, on the other hand, do not view the principles in isolation. Each principle is part of a web, such that, for example, respect, responsibility, and reciprocity need to be renewed. That is the polishing of the chain. And that renewal itself is part of respect, responsibility, and reciprocity. This is in opposition to the fragmentary nature of Eurocentrism, in which each principle can be viewed as in a dictionary separately and in isolation. The Supreme Court held that the Robinson Treaties are relational, and I respectfully submit that the Anishinaabe principles exist in relationships. One cannot show or manifest respect, responsibility, reciprocity, or renewal in isolation. They exist in relationships between people. The fragmentary approach adopted by the Crown contradicts the Supreme Court's definition of polycentric, which is something that involves a large number of interlocking and interacting interests and considerations. It's taken from Pushpanathan v. Canada, Minister of Citizenship and Immigration, 1998, 1 Supreme Court Report 982 at paragraph 36. And this same paragraph, Your Honor, is cited to by Canada at paragraph 96 and 125 of their factor.
Could you, sir, could you please spell for me the first name of that case?
Yes, Your Honor, it is Pushpanathan P-A-N-A-T-H-A-N.
Thank you.
So polycentric then is similar to the law and governance web in which the Anishinaabe principles are situated in. You'll recall Elder Rita Corbier's testimony and how it is indicative of how the Anishinaabe perspective differs from the Eurocentric one. As discussed at paragraphs 167 to around 171 of Brestuel, the Supreme Court discusses how Elder Corbier spoke about the difficulties in translating Anishinaabemowin into English and vice versa, including sometimes that there was no direct translation of certain concepts and words. In the passage from Elder Corbier's oral testimony, excerpted at paragraph 170 of Brestuel, that the Supreme Court of Canada added emphasis, Elder Corbier gave the following account of how, quote, graciously pleased to order, end quote, would have been understood by the Anishinaabe. And she said, and I quote, and the way the Anishinaabe lived with the 7 teachings, to be generous, to be kind, to be truthful, and all those good teachings, good hard teachings that were given to us. If they lived those, then they would also expect then they would expect the leader, the queen, to be living the same way. We have the same beliefs because she is the main leader of Anishinaabe. And in the same way, the Anishinaabe expected the queen to be the same way as their beliefs, that she would show love according to the principles of respect. Love and honesty, and that she would do right by the people, end quote. Both instances, the Crown have analogized the current matter with the law around the duty to consult and accommodate. We respectfully submit, Your Honor, that the law about duty to consult and accommodate are distinguishable, as that duty is within a certain socio-political power dynamic in which accommodation has been held by the court as not meaning a First Nation has a veto, and that agreement on accommodation to a First Nation's concern is not necessary. Here, though, we are dealing with a clearly 100% trans-systemic relationship explicitly entrenched in a written document created by an agent of the Crown. The Crown must be honorable. The Crown must be led by the shared goals and expectations and understandings as they were in 1850, which explicitly includes the Anishinaabe principles of respect, responsibility, reciprocity, and renewal, and the Crown's commitment to being liberal and just. Shared goals, expectations, and understandings unquestionably implies a trans-systemic situation. What is notable about the discussion at paragraph 180 in Brestuel is that the exercise of determining the form, level, and aim of sharing required by the augmentation clause, that neither the Court of Appeal nor the Supreme Court included mention of polycentric considerations. The exercise, according to the Supreme Court, is what the task of reconciliation demands. In paragraph 324 of the Court of Appeal's decision, and excerpted in paragraph 180 of the Supreme Court of Canada's decision, the Court of Appeal wrote, and I quote, the remaining task of interpretation and the basis of implementation lies in determining what the sharing relationship envisioned by the Anishinaabe and the Crown in 1850 would look like today, and how that relationship can be brought about. In this passage, we see that the Crown is incorrect here in parsing into interpretation from implementation in their factums, as both are permeated with the trans-systemic sharing relationship envisioned by the parties in 1850. Turning to our last point, Your Honor. We say that the Crown's seeming unwillingness to invest in actually learning about First Nations perspective on treaties in a consistent fashion is demonstrated in Ontario's dismissal of the role of the stage one evidence in their factum responding to the intervenors at paragraph 11. That evidence is and was, in our opinion, in our respectful submission, a readily accessible way to learn something about the Anishinaabe perspective, even with the legal team turnover. While while the Crown can do whatever they want in exercising their discretion, they cannot honorably claim before this court that ignoring or minimizing the Anishinaabe perspective or solely understanding it from Eurocentric perspective is just, liberal, and furthers the goal of reconciliation. Common law jurisprudence is clear on this. The Crown's honor is not a, quote, mere incantation, end quote, but it is instead a, quote, core precept, end quote, that finds its application in concrete practices. Those quotes are from Haida at paragraph 16, Your Honor. It is a widely known fact that First Nations across Canada are experiencing, have, and continue experiencing financial hardships. And yet First Nations continually have to return to court to try to educate the Crown about their perspectives, laws, and understandings related to the sacred agreements with the Crown. Compounding those financial costs was, as noted by Your Honor last week, the turnover in the Crown's legal teams, how it is not apparent there is any corporate memory, and how it is easy to say that the Crown is learning and engaging in Anishinaabe principles. Even active learning, as claimed by Ontario, is insufficient as the pupils continue to change. Because, for example, I would be surprised if the Canadian school that if students in the Canadian school system could attend via ever-changing proxies and still be able to graduate. Yet that is essentially what the Crown is attempting to do here and generally in their interactions with First Nations. Every lawyer in this room has made a commitment to learn the common law legal system. It is our position that the same commitment should be made to the legal systems that must be, according to the Supreme Court, reconciled with the Crown's assertion of sovereignty. Each Crown in Canada must take steps to set up a system or process or something, anything, to address this structural deficiency in the treatment of First Nations within the Canadian legal system. Although speaking about Aboriginal rights and not trans-systemic legal agreement, the Supreme Court stated in the passage from Vanderpeet, mentioned earlier, that fair, just, and true reconciliation is possible only if equal weight is placed on the Anishinaabe perspective as well as on the common law perspective. Robinson appears to have attempted to do this. But as the Crown began to assert increasing dominance over the territory and its people, they apparently decided that they no longer had to. This is not honorable. This is not just. The Supreme Court was clear. The treaty relationship requires renewing because the Crown ignored the calls of their treaty partners. And in so doing have severely, as the Supreme Court of Canada has indicated, paragraph 286, severely undermined the spirit and substance of the Robinson treaties. It is not the Anishinaabe who undermine the treaty relationship. It is the Crown. So whatever this court decides, and those that will be reviewing the decision undoubtedly, compensation for the past is not the end. And repairing the treaty relationship requires more than simply paying money. Proactive steps need to be taken by the Crown to acknowledge the new legal landscape and reality that treaties are a trans-systemic agreement that requires the Crown to develop an understanding of what and how the treaty partners understood and understand the sacred promises that were exchanged. This is true reconciliation that the Supreme Court has spoken about. This litigation, Your Honor, has been historic, but it is not the time for any party to rest on their laurels, and the Crown's willingness to actually learn will be required if we are to move forward to achieve the goals and to achieve the kind of Canada that our grandchildren deserve. Those are my submissions. My learned friend, Ms. Boise-Parker, will read soon. Thank you, Your Honor.
Thank you very much.
Thank you, Your Honor. I'll go back to where I was starting with respect to the standard of review. And Ontario's submissions on this seem to be very clear, but I say that they were overly simplistic and hide a number of problems. I think the argument was something like this: judicial review governs the exercise of state power. The default standard of review for administrative law is reasonableness. Therefore, the standard of review here is reasonableness. And you have to subject the minister's decision to the type of analysis set out in Vavilov. And I think that was the submission, was that it's not that that's a useful tool, that is actually, as a matter of law, what's required. Now, we say there's a number of problems in that chain of reasoning. And I'll try and identify them. Generally speaking, there's two significant hurdles that my friend has to clear to persuade you that the reasonableness standard from Vavilov applies here as a matter of law. And I'm going to start my submissions on that proposition that it has to be the one that's applied. And then we can talk about whether or not, even though it's sui generis, it should draw from Vavilov. That's a different question. So first, you have to be persuaded that this is the type of case where the Supreme Court of Canada has said there is a presumption of reasonableness. And then he has to show that this is not one of the cases where that presumption is rebutted. And he has to do so in the face of law that clearly states that the scope of Aboriginal and treaty rights and other constitutional questions that give rise to rule of law concerns are not reviewable on a deferential standard. Now, the first problem with Ontario's argument is this case isn't about applying administrative law, it's about applying constitutional law. Ontario says because it involves a court review of state action with a public character, it must fall within the realm of administrative law. But we all know that Canadian public law that regulates the power of the states is broader than administrative law. There's three kinds of public law: constitutional law, criminal law, and administrative law. Now, these aren't watertight compartments. Sometimes administrative decision makers have to address constitutional issues. But this is a case brought by way of action for compensation for breach of solemn treaty promises. It remains an action about breach of treaty. The fact that the Supreme Court of Canada gave the defendants an opportunity to remedy the breach before the court considers the appropriate remedy does not transform these proceedings into an application for judicial review. But I have to say, I think my friend's argument actually is based on the long view. I think what he's trying to say is, in the future even, when the Anishinaabe disagree with the decision made by the minister and the exercise of discretion, they're going to be limited to an application for judicial review, which we say is the wrong analysis. But this case certainly is not an application for judicial review. Administrative law is a subset of public law. It doesn't mean that's the only place where state action can be reviewed. And we know that because we have cases like Grassy Narrows that involve treaty obligations that are actions. They're not administrative law decisions. We have all kinds of charter cases that are actions. They're not administrative law decisions. Administrative law is the law that regulates the operation of the administrative state and delegated decision makers, the plethora of agencies and decision makers that administer a very wide range of schemes and policies and laws that government has developed itself relating to diverse matters that are the subject of government regulation, from granting forest licenses like in Haida, to extradition like in Lake, to the disposal of public lands. Sometimes they use prerogative powers while they're doing them, but they're in the pursuit of government policies and programs. And the deferential approach to review of those decisions is a direct result of the fact that the legislature provides decision-making authority to these administrative actors as part of its government regulation. And that, we say, is a very different context than the case before you. And we can see this if we look at some of the seminal administrative law cases from the Supreme Court of Canada. So the first one that I have in the book that we handed up there is the Dunsmuir case. And just in passing, I'm going to note paragraph 1 of this, where it talks about it's time for the court to consider the troubling question of the approach to be taken in judicial review of decisions of administrative tribunals. And it goes on to talk about how difficult this has been for the court to settle on an approach. The recent history of judicial review in Canada has been marked by ebbs and flows of deference, confounding tests and new words for old problems, but no real solutions that provide guidance. So my friend tried to say this law is as old as the hills and it's always applied to all these actions. This law is developing, changes all the time. And it's the law that we see here is law that is meant to address a very specific modern problem about the administrative state. So if we
In law or in Dunsmuir, the law we see here.
yes. So if we go to paragraph 27, the third sentence, judicial review seeks to address an underlying tension between the rule of law and the foundational democratic principle, which finds an expression in the initiatives of Parliament and the legislatures to create various administrative bodies and endow them with broad powers. That's what it's about. It's about Parliament and legislatures set up agencies, set up statutory schemes, and they're administered by these decision makers, and this is the law that governs that. Courts, while exercising their constitutional function of judicial review, must be sensitive not only to the need to uphold the rule of law, but also to the necessity of avoiding undue interference with the discharge of administrative functions, and here's the key, in respect of the matters delegated to administrative bodies by Parliament and the legislature. So here you have the concern about the rule of law. You don't have a countervailing concern about respecting legislative intent to delegate a decision to an administrative body. That's not what this case is about. In paragraph 28, 3 lines in, judicial review is the means by which the courts supervise those who exercise statutory powers to ensure that they do not overstep their legal authority. That's not what we're talking about here, the exercise of statutory powers. We're talking about whether the Crown has overstepped its authority that it draws from a constitutionally protected Section 35 treaty. Paragraph 30. In addition to the role judicial review plays in upholding the rule of law, it also performs an important constitutional function in maintaining legislative supremacy. That's not what we're concerned about here. So you'll remember in Dunsmuir, the court said, we have all these different tests. We have the, functional test, and we have all these different tests whereby they tried to decide what standard of review would be applied to what administrative decisions based on a variety of factors. And it was very confusing. They said they were going to straighten everything out in Dunsmuir, go down to the two different standards, reasonableness and correctness, get rid of patently unreasonableness. But that still didn't sort everything out. And so then we have Vavilov, and they say, now we're going to sort it out. And so at paragraph 4, over the past decade, the law relating to judicial review of administrative decisions in Canada has been characterized by continuously evolving jurisprudence and vigorous academic debate.
And this is paragraph 4.
Sorry, I'm sorry about that. Yes, of Vavilov, which is tab 2 of the compendium.
Got it. Thank you.
And it says, and it's the third or second sentence, this area of the law concerns matters which are fundamental to our legal and constitutional order. And there they're talking about the lines between the legislature and the executive and the courts. It doesn't have anything to do with constitutionally protected rights of First Nations people. And seeks to navigate the proper relationship between administrative decision makers, the courts, and individuals in our society. That's not what we are doing here. We're talking about a nation-to-nation relationship. We're not talking about the relationship between an administrative agency and an individual. In parallel with the law, the role of administrative decision-making in Canada has also evolved. Today, the administration of countless public bodies and regulatory regimes has been entrusted to statutory delegates with decision-making powers. That's what administrative law is about. And it goes on to say the number, diversity, and importance of the matters that come before such delegates has made administrative decision-making one of the principal manifestations of state power in the lives of Canadians. That just has no application here. We are not talking about the administration of a public agency. We are not talking about a regulatory regime. We are not talking about a state-sponsored program. We're talking about an alliance between equals and the Crown's constitutional obligation to maintain an honorable treaty relationship. Now, my friend says exercises of the prerogative can be subject to a judicial review. That's true. But that doesn't mean that all exercises of the prerogative can only be challenged by way of judicial review. And my friend referred to, didn't take you to the Hapakasa Nation case and talked about how that's authority, that entering into treaties is an exercise of the prerogative. I think it's important to be clear that that case was a duty to consult case. That's what the Hapakasa Nation was doing there. And they were saying that when the government decided to enter into a treaty with China, that it had to consult with them beforehand. It had nothing to do with the Crown giving effect to its own obligations under a treaty with First Nations protected by Section 35. In that case, it was just a question that the Crown didn't engage in any consultation. And the question was that a mistake not to engage in consultation? And the court didn't have to decide on a standard of review because everybody agrees that is reviewable on the standard of correctness, whether or not you have to consult. And I just want to, while I'm on the Pakiseth case, Ontario glossed over a difference in their position from that of Canada. Canada doesn't insist this is a judicial review. It does argue that a deferential standard applies to this sui generis review. And I think Canada acknowledged in its oral submissions that there is a question about whether judicial review of a federal decision can take place in this court in this kind of proceeding because of the Federal Courts Act. And my friend said that was resolved by the Black case that he took you to about Mr. Black wanting some honors from England. But I think in the Hapakasa case, the Federal Court of Appeal revisited Black.
Can you give a spelling of that for the reporter, please?
Hupacasath. And maybe I'll just ask my friend to find out where it's cited in the Crown's factums. So they revisited the conclusion in Black in Hapakasa, and there is at least a question. It may very well be a matter of concurrent jurisdiction, but there is at least a question about whether this decision of a federal minister would fall within what would be the exclusive jurisdiction of the federal court to conduct an actual judicial review.
And as this unknown future unfolds, and Canada and Ontario continue to act as crowns, do you say there is possible that there could be two separate jurisdictions?
Well, one of the points I was going to make a bit later is it seems a bit unseemly for the crowns to come here and say the court should be deferential to their determination without actually really identifying the precise authority under which they made their respective determination. Ontario sort of refers to the prerogative, but doesn't really explain how or why these particular ministers got the authority to make the specific decision that they did. And I think that's obviously because both crowns are still dancing around the question of who's responsible. Now we say the source for the authority to make the decision about the proceeds of the treaty and how it should be, the proceeds of the treaty territory and how it should be shared is the treaty itself. We say that's how the Crown obtained the authority to regulate the use of resources in the territory and collect revenues from those resources. And after 1867, the federal and the provincial crowns may have chosen to organize themselves in some particular way, but any authority either of them have today to make a decision about sharing the wealth from the territory derives from the constitutionally protected agreement between the Anishinaabe and the Crown. And we say the judicial supervision of those decisions arises from the court's duty to uphold the Constitution. and not from the authority to ensure that administrative decision makers stay within the limits of any power granted to them by statute or prerogative, which is what you would normally be doing in a judicial review. Now, even if it is a prerogative power, as Ontario says it is one that is limited not only by general principles, but by the treaty obligations. And that's what we say makes it a question of constitutional law. Interpreting the contours of that power is a Section 35 question. So our first primary point then is that our friend is wrong that Vavilov has to apply because this is a case of administrative law and therefore the default provision or the default standard of review should apply. We say it's governed by constitutional law that applies to the solemn promises the Crown made. It's not about protecting the Anishinaabe in their interactions with the administrative state or an administrative decision maker implementing policy or legislation. It's about the Crown's role as treaty partner. And I wondered why Ontario felt it was necessary to kind of double down on this being actually a judicial review, as opposed to a sui generis review, a position Ontario has taken, but I don't think it's shared by Canada. And I think one reason is because it gives an impression of simplicity to the choice of a standard of review. But I also think it's because Ontario knows if you approach this review as a sui generis one, and you develop an approach to the court's review of Crown discretion in a manner that really does take into account what's happening in the context of a constitutionally protected relationship, you actually can't land on a fully deferential standard of review. And the treaty is not, in our respectful submission, just color that informs an essentially deferential standard. It is a sacred relationship of equals, and it demands a different approach. And we also thought about why we're so offended by Ontario treating it as an administrative law decision. Because, as I'll get to later, even if it is, they still don't fit within the they still don't fit within the cases that would attract a reasonableness standard, because it's clearly a matter of constitutional law, it's a matter of the rule of law, it's a matter of the scope of treaty rights. So to some extent, does it matter? But it does matter, because we think that treating this like a case to be decided under administrative law principles really ignores its fundamental character as a dispute between two nations. It ignores the fact that what the court is supervising is not the unilateral implementation of government policy by a delegated decision maker, but rather a constitutionally protected relationship. In fact, we say that the Crown's characterization of the decision as just an administrative law decision is a further attempt to erase Anishinaabe law and Anishinaabe principles and the nation-to-nation character of the agreement from the treaty relationship.
And what do you say in this this point I believe you're making, that this court must understand that the sui generis relationship demands a sui generis consideration or review of this Crown decision in the face of very strong language from the Supreme Court about the parameters of the review?
So because we think it is a sui generis review, and I took you to the I took you to the parts of the court's decision, I think, where I say they define the scope of the obligation as including the constraints on the Crown's discretion. And what we're talking about is how deferential. I think the appropriate approach to this is to say you're not bound by Vavilov because it doesn't actually apply. You have to come up with a sui generis approach. But the sui generis approach has to be responsive to what the Supreme Court of Canada said. And what the Supreme Court of Canada said is that the decision must be consistent with various things, including it must be consistent with the honor of the Crown, it must be consistent with the duty of diligent implementation, which requires first a generous interpretation of the treaty and then steps taken to implement it. It has to be consistent with being in a relationship with the Anishinaabe based on those principles that we've discussed. It has to be consistent with the obligation to be liberal. And we heard the Supreme Court of Canada quote from Elder Rita Corbier about that meant acting with love and generosity. It has to be held to what we put all those things together, we call that the standard of an honorable treaty partner. And it's this court's obligation to ensure that the Crown acts in accordance with the standard of an honorable treaty partner. Now, I'll skip to the chase. We say that the court did say that when it comes to balancing polycentric considerations, the court should recognize that the government has some expertise in that. So I'm going to take you to what I think is explanation of how I can do that now if you like. So my friends say it's either correctness or it's reasonableness, it's either deferential or it's not. And they said the thing about says there's more than one possible result. It has to be reasonableness. They say we're wrong to say it's not a binary choice. I want to be clear about what we said about it being a binary choice. The fact that there may be more than one outcome that is consistent with an honorable treaty partner does not mean the Crown must be deferential to the Crown in all of its determinations about what is honorable. That the court must be deferential to the Crown's assessment of what is honorable in all respects.
Let me just, and this is a point you made earlier.
Right. And I'm responding in part to them saying it has to be binary. We agree it's deferential. You know, when the court's going to look at something that the Crown decided, you're either going to show some deference or you're not. Right? And your question, what the Supreme Court of Canada told you to do is see if it's honorable. And it said when they're talking about balancing polycentric considerations, take into account that they have some expertise in this. In the same way that under Vavilov type questions, statutory tribunals have expertise in certain things. And that used to be the basis on which you would provide them deference. You would say, is this question within the scope of expertise? Vavilov says we're not going to do that anymore because Vavilov says the mere fact that the statute gave the decision to the administrative decision maker means that to respect legislative intent, we have to proceed on a default of reasonableness. You don't have that logic applying here. Here, you still have to see why would the court be deferential? And the Supreme Court of Canada gave you a reason, because they think that the Crown has expertise in balancing polycentric considerations. So to the extent that that is what the Crown is doing, then you have to show some deference. And then Vavilov is useful to you, not because it applies as a matter of law, but because it's a useful kind of exercise that my friend took you through. So I think it's easiest to do this sort of with an example. So we say the deferential review, there's no need to have deference with respect to the entire review process. So in my friends, in Ontario and Canada's decision letters, they explain sort of how they got to where they got on what have been referred to as sort of the three big items. So the first one, let's say, is what's in the pot. And this involves sort of two questions. One is, does the shareable wealth include just NCRRs, or does it include something broader than that about what the Crown collects as a result of the resource use? So rents, or however you want to characterize it, versus NCRRs. And that seems to be a question of giving effect to the common intention of the parties to the meaning of the treaty in a modern context. It is a question of interpretation. Crown, there's no reason to be deferential to them on that. That's not about balancing polycentric considerations. That's about understanding what the parties meant. I think Canada agrees that's a question of interpretation. That's why we were concerned and wanted to intervene, because we didn't want this court to adopt an interpretation of the treaty that would lead to NCRRs being the only thing that could be considered. But there's nothing in the Supreme Court of Canada's decision that would suggest that this court should be deferential to the Crown's determination about whether it has to take into account just one stream of revenue or the Crown's overall benefits from the territory. And I would say it would be very hard for you to be deferential on that point in this case, because the Crowns don't agree. Ontario has taken some indirect revenues into account. Canada hasn't. Now, once you decide that issue of principle and treaty interpretation, does the Crown have to have regard to its overall resource revenues or just a stream of NCRRs, then there might be a variety of ways to estimate those revenues. And more than one of them might meet the test of reasonableness. Honorableness, I keep mixing those up. I guess I've been doing administrative law for too long. And here it seems like Ontario and the First Nations agree that adding 25% of NCRs in this particular case is acceptable. So in the face of the parties' agreement, I don't know if the court has to decide whether one is only one way is honorable. I want to clarify, so that's sort of about, do we put NCRRs plus rent, or what do we do about that? And then there's a question, well, how do you count the NCRRs? Or maybe how do you count the broader revenues? And I want to clarify what Ontario said about our position on this, because they said that we said that was a matter of deference. And I agree that probably my submissions weren't as clear as they could have been. And in fact, I think I kept using the word reasonable when I meant honorable, and I'm going to have to take you through that because that was my fault. I did tell you I was doing that halfway through, but I'd like to tell you exactly where I did that. But here's our position on that. If there are NCRRs, if there are differences in principle about how they're to be counted, There's no reason for the court to defer to the Crown on that. That again is not a polycentric consideration about balancing its responsibilities to other Canadians against its treaty obligations. That's just interpreting what the parties would have intended when they said, can Canada do it without incurring loss? And I'm not as familiar, obviously, with the stage 3 evidence as everybody else here, but if there, as I understand it, there might be a matter of principal difference between how Mr. Hutchings and Bodway and Smart estimate or decide what are the relevant revenues. If I remember right, Mr. Hutchings says it's only the revenues that contribute to the actual revenues you're counting. And for Bodway and Smart, it was, they take into account more expenses associated with the resource itself.
You said revenues versus revenue, I mean, expenses versus.
Expenses versus revenue. So as I understand it, David Hutchings says, when you're deducting expenses from the revenues, you only deduct those expenses that went to generating those revenues or had a reasonable expectation of doing that. As I understand, Bodway
Expenses incurred to
generate the revenues that you're counting is in the pot. As I understood it, Bodway and Smart had a broader view of that. If you might decide that one of those ways of doing it is honorable and one is not, you don't have to defer to the court, to the Crown on that. That's not a matter of balancing polycentric considerations. I mean, Canada told you that it made its decision on these things by weighing the evidence just like a court would. So there's no need to defer to the Crowns on that exercise. And in fact, it would seem inappropriate to do that since they generated some of that evidence themselves. However, and I think this is what I meant that my friends seized on, there may be various ways to calculate things that are more like, how do you count the beans, that don't have any real implications for the honor of the Crown or the treaty principles or anything like that. In that case, any of the methods would be honorable. And then the Crown can choose. They don't have to choose the one that you think is best, that the court would have chosen, as long as they meet the threshold of being honorable.
As long as they meet the threshold of being honorable?
Yes. And by honorable, I have wrapped in all those things that are listed in the Supreme Court of Canada's decision as being constraints. So they have to be liberal, has to be just, has to be taking into account the Anishinaabe Treaty principles and so on and so forth.
So if I have this point, it's that the debate on expenses, which was, I think at one point narrowed down in cross-examination to whether expenses are incurred to generate revenues or rents. You say that is not a decision that takes into account polycentric considerations.
Right. It's not about because when the Supreme Court of Canada is talking about that, they're talking about balancing competing considerations, the variety of the Crown's obligations. And as I said in my first submissions, you'll remember the Anishinaabe Treaty principles do include respect for one treaty partner's autonomy. So, providing respectful attention to and giving some room to maneuver on that particular point is not inconsistent necessarily with the Anishinaabe Treaty principles. But the Anishinaabe would not have agreed that the Crown is going to be the fact finder, or that the Crown gets to interpret the obligations or the party's intentions. So going on through this sort of application of what I say is where you have to apply deference and where you don't. where you have to take into account the Crown's particular expertise. With respect to the bring forward rate, which is another one of these big three, it appears Ontario considered this under factor 3 of the Supreme Court of Canada's factors, benefit to the Crown, instead of considering it under factor 1, which is the nature and severity of the breach. That may be an error in understanding, the principles of what's required by reconciliatory justice. I mean, apparently Ontario, I think, said that they didn't think they had to have regard to the losses in that regard. They had to pay attention to what they gained.
Your Honour,
Sir.
consider this may be beyond the scope of the intervention in dealing with the application of the 5 factors directly to the amount of past compensation. Sorry to my friend for interrupting.
Thank you.
I appreciate that concern. I'll try not to, I'm not trying to say this is what you have to decide. I'm saying this is what you have to decide. I'm not telling you how I think you should decide it, if I can draw that distinction. So I don't think that, all I'm saying is I don't think that's the kind of decision that would attract the deference associated with polycentric concerns. However, the third issue that has been discussed, how much is going to be shared, that would trigger that. Now, again, it's a challenge because the two crowns take different approaches. So it's hard to know how one differs.
You say that triggers that triggers an application of polycentric concerns.
Yes. And in that we say, when you're considering that that question, Vavilov might be helpful to you, and the process set out in Vavilov, not because it applies as a matter of law, but because of the court, because it might be useful given 3 things: the relational aspect of the treaty, the respect for autonomy that the treaty partners acknowledge, and the Crown's expertise. Now, one thing that's not in the condensed book is paragraph 300 of the Restoule decision. I do have an extra copy of it here if you'd like it, but I thought you might have a copy of the Supreme Court of Canada's decision going. Would you like me to hand up paragraph 300?
Of the SEC?
Yes.
I have it if you want to.
Okay.
To it. Paragraph 300.
Yeah.
Go ahead.
So I just want to point this out because this is where the court is talking about why it sent it back. Or why not sent it back, why it gave the Crown a chance to make the right decision. And at paragraph 300, it says, as the trial judge found from the Anishinaabe perspective, the central goal of the treaty was to renew their relationship with the Crown. For the Anishinaabe, the treaties were not a contract and were not transactional. They were the means by which the Anishinaabe would continue to live in harmony with the newcomers and maintain relationships in unforeseeable and involving circumstances. And then they quote the Hurons plaintiffs, but the treaty promises is an ongoing relationship with procedural and substantive aspects. The Crown cannot fulfill its duty by paying an arbitrary sum of money without engaging its treaty partner. And this is the point, the superior plaintiffs would be deprived of the relational aspect of the treaty if stage 3 of this litigation were to proceed as currently conceived. Accordingly, stage 3 should not proceed directly to a traditional damages calculation. So they were sending it back in part because of the need for them to have that relational aspect, for them to understand the Crown's behavior. So ultimately, we say,
For the Anishinaabe to,
understand the Crown's position. Because as I said in my previous submissions, one would hope, and I won't take a position on whether or not this happened here, one would hope that when the Crown gave its decision, it would be transparent and intelligible and all those things they talk about in Vavilov, so that a person who reads it understands why the Crown made the decision it did, what role polycentric considerations played in that decision, and how the decision is consistent with the requirements on the Crown, including the Anishinaabe Treaty Principles. So even with respect to polycentric concerns, it is ultimately up to this court to decide if the Crown's decision is consistent with the standard of an honorable treaty partner. But recognizing the Crown's expertise and balancing those concerns, it makes sense for the court to approach the Crown's explanation of its treatment of those concerns with respectful attention to what the Crown says. All those paragraphs that my friend took you to that suggest that you're supposed to pay attention to what the Crown said and review it rather than just substitute your own decision. That would apply only to this polycentric balancing. And the Crown has a concurrent obligation, as I said, to explain its treatment of polycentric concerns and why it thinks its treatment of those things is consistent with the decision of an honorable treaty partner. It has to be clear enough that both the Indigenous treaty partner and the court can assess those reasons for compliance with the constitutional standard. So the Vavilov sort of analysis, reasons first, is helpful when you come to that one part of the analysis. But Vavilov does yes. But what the Crown can't do, as I said in my initial submissions, is sort of wrap itself in a blanket of say everything is polycentric and you can't touch this at all.
but isn't the flip side or the risk that the court finds that, all right, polycentric considerations have no play in the first of the big three. What are the net benefits? Or how to calculate net benefit? Has no play in the bring forward rate, let's say. But when considering sharing, don't you get to where Canada actually said they were, and that is, well, if this goes up, then this will go down. This number will, if a number goes up, when you look at the first two items in the big three, or in the three drivers, then when we are ultimately allowed to engage in our balancing act of polycentric considerations, then we can take all of those numbers that may have been bigger and take them right down to wherever they go. Because the polycentric considerations possibly are simply increased deficit.
Well, this is why the Crown has to be has to be specific about what is taken into account, and the court does still review it with, as my friend said, it's a rigorous review. It's a robust review under that kind of reasonableness analysis that would apply to the polycentric considerations. It's not they can do whatever they want. And if it appears that they are pulling a number out of a hat that isn't connected to all of those But the final number has to reflect all of those considerations that the Supreme Court of Canada said, including the needs and the impact of the breach and the honor of the crown and all of those things. If they're just picking a number because they like that number and they can't demonstrate how it actually reflects those things, then it's not honorable.
Right. That wasn't the premise of my question, though.
Okay.
It was, let's say there's full engagement in trying to understand or trying to incorporate treaty principles into each of their assessments. And there is an intelligible logic to the decision. But that the last paragraph of the decision is doing all of that results in X if we share at this percentage rate, or if we consider a share that amounts to a number, whether it's expressed in a percentage or just in an amount.
Well, I mean, the Supreme Court of Canada said it has to reflect the revenues from the territory. And it has to reflect the fact that the treaty is supposed to be mutually beneficial. And it has to reflect the principles of reciprocity and respect. So if the thing is like this, and the decision is to give like this, it's not going to be consistent with all of those things.
For the purpose of the record, there was a big and then a smaller.
Yes, if the revenues are very, very large and the amount is very, very small, then the court has to inquire very closely as to how that can reflect the principle of being liberal and generous and consistent with reciprocity. But they at least have to do the exercise. So everyone needs to know. They can't say, well, we're only sharing X billion dollars if it's really 10 times that amount. Otherwise, the court can't take a close look at it. So they have to be right on those factual issues.
Thank you.
And just on that issue, we had made submissions and say in our reply factum that the onus should be on the Crown to come and persuade the court that its decision is honorable, notwithstanding that it wasn't one that was reached by agreement. And my friends both say, well, that's not how it works in a review of an administrative law decision. We agree this is a sui generis problem. And it's because the treaty relationship is supposed to be based on sort of mutual benefit, mutual agreement, mutual understanding, and the Anishinaabe protocols that the Crown knew the Anishinaabe expected to govern the relationship would have been all leading towards consensus building and agreement. So when that doesn't happen, there's a problem in the treaty relationship. And the Crown should be the one who has to come and demonstrate to the court why it's okay nevertheless. And the Crown has all the information anyway in that regard. It's very different than administrative decision. I see the time. I don't know what we're thinking in terms of breaking. I do need to go back and do a few things that I skipped over in order to address your questions.
Why don't you, if you can, this is probably a good time to tell me how you've organized your time amongst yourselves so we can have a sense of breaks.
We have organized it hoping that we won't take too long, all of us. I was hoping.
Generally expressed goals and expectations.
I think I have about another 15 minutes, and I think that would be consistent with what we've said.
So what, I'm not sure how you governed yourselves this morning. Needs to be food, Mr. Shackman.
The idea I thought was after the Hurons are done in 15 or 20 minutes or however long it takes, then Tamagami would speak briefly, and then the contingent interest beneficiaries would take the balance of the day, hopefully not spilling out into tomorrow, and that I would finish tomorrow.
And so had you thought of a break for today? Had you thought of where was a good place for a break?
Well, I think if the contingent interest beneficiaries seeing the timing, if they're, are we still okay for you guys to get towards the end of the day?
No, Harley, they never were. They're 3 hours.
Oh,
Yeah.
okay, so
should take
we have 3 hours for the contingent interest beneficiaries to go.
No, she's asking about breaks.
Yeah, I know. I'm asking, I'm trying to respond in terms of the breaks as well, by trying to figure out how much time people need,
Right.
right? So that's why I was asking.
I think if we take lunch now until about 2:15, we should be good.
Yeah, that's.
Do it.
That's what I was
Thank you.
trying to get.
Thank you very much. We'll break now till 2:15. Thank you.
This court is stood down till 2:15.